Hey folks, welcome to today's Law of Self-Defense ongoing coverage of the Kyle Rittenhouse trial. I am, of course, attorney Andrew Branca for Law of Self-Defense. Today was the 7th day of the trial by which Assistant DA Thomas Binger is seeking to have Kyle Rittenhouse convicted and sentenced to life in prison for having shot 3 men, 2 fatally, the night of August 25th, 2020 in Kenosha, Wisconsin, when the city was suffering a tsunami of rioting, looting, and arson following the lawful shooting of a knife-wielding Jacob Blake by Kenosha police officers. Today, the trial heard testimony from the defendant himself, Kyle Rittenhouse, a high-stakes bet by the defense and one that always has risk of snatching defeat from the jaws of victory. This is a rare trial in which the defendant is relatively pristine, however, and where the little possibly negative evidence available has already been ruled inadmissible by the judge, which somewhat moderates the risk of having the defendant testify. In addition, there were some important points of evidence that I know it was beneficial for the defense to have made clearer and more concrete to the jury. But moderation of risk is not elimination of risk. And anytime you submit your client to several hours of more than 3 hours of cross-examination today at the hands of an experienced and arguably unprincipled prosecutor, you can be sure that the client will take some solid hits. All of that happened in today's direct examination by defense counsel Mark Richards and cross-examination by Assistant District Attorney Binger. I'll note up front that the biggest drama of the day came in the first part of cross-examination of Kyle by Assistant DA Binger, who skated perilously close to having the defense awarded a clean victory, an order by the judge to declare a mistrial and with prejudice. And Binger may win that prize yet, as the defense has, in fact, submitted a motion for a mistrial with prejudice. The with prejudice part is important because it means Kyle would not be subject to a second trial on these charges. Getting that bonus feature is very rare, however, and if a mere mistrial without prejudice were declared, Assistant DA Binger would simply pull Kyle into a second prosecution. Maybe one that would go better for him than this one. Now, I won't spend time here on the overstepping that got Binger in hot water today because I wrote about it at length in a midday post that you can find over either legalinsurrection.com or lawofselfdefense.com. Immediately after the court returned from the recess that followed that tumult, however, the parties met outside the presence of the jury to discuss matters. The first thing that happened then was the defense submission of the motion for a mistrial with prejudice, which I've already discussed above. Before I continue, though, I would like to mention the sponsor of today's content, CCW Safe, a provider of legal service memberships. Essentially, what CCW Safe does is promise to pay their members legal fees if the member's involved in a use of force event, and those fees start big and get bigger fast, folks. If you've shot someone in self-defense and they've died and you find yourself charged with murder or manslaughter, it's easy to go through $200,000 before you get to trial. So if you don't have that kind of money sitting in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because it really does. I've looked at all the companies that offer these kinds of services, and as you might imagine, and I found that CCW Safe is by far the best fit for me. I'm personally a member. Whether they're the best fit for you is something only you can decide, but I do urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member, you can save 10% on your membership with them using the discount code LOSD10, LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCWSafe. Now, one of the things that got Assistant DA Binger in hot water with Judge Schroeder this morning was his referring several times on cross-examination of Kyle to the fact that the 17-year-old had not previously sought to explain the events of that night, improperly referencing in front of the jury Kyle's exercise of his Fifth Amendment right to silence. Now, Assistant DA Binger attempted to talk away his having commented on the defendant's exercise of his right to silence in front of the jury. Binger did his usual blah, blah, blah word noises thing where he says a great deal, much of it repetitive, most of which is either pointless or apparently intended to deceive. For example, there are circumstances in which a court may allow a defendant's right to silence to be pierced, in essence, if that defendant takes a witness stand and had previously made public statements on issues relevant to his trial. In that case, the prosecution on cross-examination could ask about what was said in those interviews as well as what was not said, which would otherwise have been protected silence. Importantly, interviews in which the defendant does not speak to issues relevant to the trial would not open the door for such questioning under cross-examination by the prosecution. Here, Binger told the judge that Kyle had done a great many interviews between the events in question and the trial itself, and Binger believed that this opened the door to the aggressive questioning he sought against Kyle. On the critical question of whether the interviews were of the sort that would allow for such questioning, however, meaning speaking to the issues in the trial, which the judge specifically asked about, Binger began to get evasive and ambiguous. And this behavior suggests to me that Binger is acting in bad faith. In fact, if he actually had the content he needed to allow for more aggressive cross-examination of Kyle, he would simply have presented that evidence to the judge outside the hearing of the jury and sought the judge's approval to do that. The fact that Binger did not follow this normal process, but rather just tried to bullet through in front of the jury, suggests to me that he does not have what he needs to justify his sketchy questioning. Another misstep this morning by Assistant DA Binger is that angered Judge Schroeder tremendously was Binger's attempt to bring up the infamous CVS video in front of the jury. Now, the CVS video involves Kyle sitting in a car with someone while they watch an apparent shoplifting or robbery take place at a CVS across the street. Kyle says that he wished he had his AR. He'd send rounds in the direction of those criminals. He did not have his gun with him. He obviously fired no rounds without a gun. He did not engage the criminal in any way. It was the chatter of a 17-year-old boy. All Kyle actually did was call 911 to report the event to police. The prosecution had sought in pre-trial hearings to have this CVS video admitted as evidence at trial. The defense objected. It was argued out at length in court, and Judge Schroeder announced he was not going to admit it, but would leave the door open to further consideration as the trial developed. When Binger appeared moments away from simply discarding the judge's order, excluding mention of the CVS video from evidence, there was another explosion in the court. Now, Binger attempted to explain this away with his usual blah, 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 with a bunch of whining tossed on top. Ultimately, the judge decided again that the CVS video would not be admissible at evidence. Even more notable was, at the end of this discussion, the judge informed DA Binger that despite the prosecutor's protestations that he was about to raise the CVS video in front of the jury in the good faith belief that the judge had left the door open for him to do so, the judge himself did not believe the prosecutor had, in fact, acted in good faith, and he told the prosecutor that to his face in court today, meaning, of course, that the judge believed the prosecutor had acted in bad faith. Not one to ever give up, however, Binger now tried to get the judge to admit into evidence a photo of Kyle wearing a t-shirt that read "Free as F." You can guess what the S was on the front of the t-shirt. This was the shirt Kyle was wearing when he took photos at a local bar with some people who would later be characterized as Boogaloo Boys. Judge Schroeder had ruled pre-trial that pictures generally from that encounter would not be admissible as evidence because it would have amounted to no more than character evidence. Now Binger tried to bring into evidence specifically the t-shirt photo, arguing that it goes to Kyle's state of mind, particularly in the form of a depraved disregard for the two lives Kyle had taken, utter disregard being an important element for some of the criminal charges here. Binger also expressed outrage that Kyle had worn this t-shirt only hours after a court hearing, where Judge Schroeder would have been the judge, and while out on bail, although perhaps he was... Binger here was just trying to get the judge spun up about this conduct. During this discussion, Judge Schroeder mentioned that certainly wearing the t-shirt was poor judgment, but that the t-shirt event was 4 months after the shooting event, that everyone engages in poor judgment from time to time, and in any case, the defendant was not being tried for poor judgment. The t-shirt would not be allowed. Binger took this opportunity to assure the judge that as far as the prosecution was concerned, Kyle very much was on trial for poor judgment, as it was the state's theory of the case that none of these shootings would have occurred but for Kyle's poor judgment of going to Kenosha that night with an AR. As if we hadn't already noticed, Binger was prosecuting Kyle for violating the prosecutor's own sense of what qualifies as poor judgment. Now, let me talk a minute about the risks of having Kyle testify. So it's almost invariably a bad idea to put one's client on the witness stand in a criminal prosecution, mostly for three reasons. First, most criminal defendants are, in fact, guilty. In fact, they are guilty not only of whatever the current charge is, but of a lifetime of criminal activity, arrests, convictions. It must be assumed that all of that bad history will come out on cross-examination, and that is obviously devastating to the defense. Second, even innocent clients with clean histories in terms of the law often have facets of their lives that can be misrepresented to make the client look bad in some way. You have a Confederate flag themed ice cooler from the 1980s on that shelf in your garage that you've forgotten all about. Well, in 2021, that makes you a racist. You see how that would go? Third, even if that's not a problem, many clients are not, to put it nicely, quite as intelligent and controlled in their emotions as their attorneys might like them to be, making them easy prey for prosecutors that will sneer and deride the defendant under cross-examination, twist every answer into as evil a statement as possible, and through their own questions attempt to infuse into the jury a negative sense of the defendant. These are the "isn't it true? Isn't it true you just wanted to kill that person?" kind of questions. It hardly matters what the answer is. I mean, obviously the answer will be no, but the question is in the jurors' minds. Also, defendants may be goaded into defensive outbursts or angry outbursts or misstatements that can be presented to the jury as outright lies or even admissions. Naturally, once the client takes the stand, their lawyer has entirely given up control of what happens during cross-examination by the state. So generally in the legal profession, the risk is not worth the few benefits one might hope for by putting your client on the stand. The juice is not worth the squeeze, as the expression goes. That said, in many respects, these risks are mitigated in the case of Rittenhouse. Kyle doesn't have a real criminal record, although it seems he was driving without a valid license for some time, and yes, Binger was sure to bring that up. There's also, of course, the purported unlawful gun possession charge, but that's still only a charge, and Judge Schroeder would not allow Binger to comment on it much because it's still not clear how the jury will be instructed on that charge. What few incidents in his young life might have been used against him, like the sister fight video or the CVS video or the Boogaloo encounter, had been ordered excluded by Judge Schroeder and remained so ordered, as the judge confirmed this morning before Kyle began to testify. That still leaves the third risk, however, that Kyle might be goaded by the much older and very experienced prosecutor Binger into making a misstatement that could be mischaracterized, at the very least, the unavoidable reality that Binger can phrase his own questions in a manner to cast Kyle in as negative a light as possible. Now, Kyle made few real misstatements, but the negatively cast questioning was an ever-present factor throughout this very long, more than 3 hours, cross-examination. Before we get to cross, however, let's first step through the direct questioning of Kyle by his defense attorney, Mark Richards. Now, the announcement that he was going to be a witness certainly sent shockwaves through the community watching this trial. As one would hope, everything in Kyle's direct testimony was thoroughly consistent with his core legal defense of self-defense from the very first minutes when Richards asked, "Would you have shot Rosenbaum if he hadn't chased you and fought you for your firearm?" And Kyle naturally answered no. The defense also sought to fill in some holes and buttress some weak spots and negative suggestions that Binger had made earlier in the trial. Richards had Kyle describe his many associations with Kenosha, including working in the city, his father living there, much of his extended family living there. Binger had suggested he was some outsider of the community. Richards buttressed Kyle's civic-mindedness, having him testify about being in his local police department's Police Explorer program and in the fire department's cadet program. Kyle talked about his cleaning graffiti in Kenosha, as documented by the now famous Nathan DeBruin photo. as well as recounting how he had personally met and talked with Sal and Sam Kindry, the owners of CarSource, receiving a ride from Sal and exchanging phone numbers with Sam. As other defense witnesses had testified, he described the owners as being happy to see the volunteers present to protect their riot and arson-torn businesses, even offering to pay them for their efforts, although this payment was never actually made by the CarSource owners. Kyle testified about encounters with Rosenbaum, who was swinging a chain and had threatened to kill Kyle not once but twice. This included the infamous and direct threat, "If I catch you alone, I'll kill you," as well as a later, more general threat to the group Kyle was with to cut their hearts out and kill them. Kyle talked a bit about providing medical help to a number of people, wandering around doing that and putting out fires, getting stuck behind the moving police line so that he was separated from most of his group, going to Ultimate Gas to look for Ryan Balch, from whom he'd become separated, and receiving a phone call from Dominic Black to rush to the 63rd Street CarSource location to put out fires reported there. It was when Kyle reached the 63rd Street CarSource with the fire extinguisher that he would be ambushed and murderously pursued by Rosenbaum, and ultimately shot and killed Rosenbaum in that CarSource parking lot. It was when Kyle sought to testify to the details of this terrifying encounter that he became emotionally distraught, sobbing on the witness stand to the point of being unable to speak and continue. Judge Schroeder, at that point, ordered a short break. When the court returned to session, the direct examination by Richards continued with the recovered Kyle. Kyle described how he had arrived at the corner of the CarSource lot to come upon Joshua Zeminski, who he did not know at the time. He saw Zeminski holding a gun in his hand. Zeminski took a step towards Kyle, and Kyle dropped his fire extinguisher and stepped back in response. It was then that Rosenbaum came out from hiding in the nearby cars and, as Kyle put it, ambushed me. Kyle began to run, hearing Zeminski scream behind him to Rosenbaum, "Get him and kill him." Kyle also heard a shot from Zeminski's position behind him. As he ran, Kyle momentarily turned, pointed his gun at the pursuing Rosenbaum in an effort to deter his chase, but Rosenbaum would not stop. Kyle ran a short distance more until getting entangled in a group of cars and seeing the large and violent crowd ahead of him in the parking lot. At that point, Kyle turned back to the onrushing Rosenbaum, who lunged at and got a hand on the muzzle of Kyle's gun, and Kyle fired 4 times in 0.76 seconds until he was no longer a threat, Kyle testified. The next compelling testimony from Kyle on direct was his recounting getting attacked in the street as he ran for the police line to turn himself in to authorities. He got struck in the neck by Anthony Huber's skateboard, being swung like a bat, and a moment later is struck in the back of the head with a chunk of concrete held like an impact weapon. He goes faint, he stumbles, he falls to the street. There he is face-stomped by Jump Kick Man, who he fires at twice, missing, and Jump Kick Man prudently flees, never to be seen again. Then Huber strikes twice more with the skateboard, this time in the head, and grabs the muzzle of his rifle. Kyle can feel the rifle sling slipping from his body, and fearing the loss of his rifle, fires a single fatal round into Huber's chest. Next, Grosskreutz rushes up to Kyle with a pistol in his hand, breaking hard with raised hands when Kyle notices him, then rushing in again and pointing the gun at Kyle's head when Kyle looks down. It's at this point that Kyle fires a single round into Grosskreitz's bicep. Kyle also pointed his gun at some others, rushing in at him, but doesn't shoot when they prudently decide to reconsider their attacks and instead flee. At that point, Kyle ran to the police line where he attempted to surrender but was rebuffed, returned briefly to the CarSource lot on 53rd, then went home where he promptly turned himself into his local Antioch Police Department. And that was it for direct questioning of Kyle. And it brings us to the cross-examination of Kyle by Assistant DA Binger, which totaled over 3 hours in duration. It was during this start of cross-examination that Binger so thoroughly stepped over the line, as we documented in our midday post, which I've linked to earlier in this content, so I won't repeat that all here. I will note in overview that the more than 3 hours of cross-examination yielded essentially nothing relevant to any element of Kyle's core legal defense of self-defense, and certainly no evidence that could to any degree of legal certainty be expected to disprove any one of those elements of self-defense beyond a reasonable doubt, which is, of course, precisely the burden the prosecution must carry to achieve a conviction, at least a just conviction, at least on any of the felony charges in this case. Instead, we got the usual pounding of the table we've come to expect of Assistant Dave Binger, who has neither the facts nor the law to pound in his favor. Now, it's impossible to go through this very lengthy cross in anything like a timely manner in summary, so I'll just hit the highlights and include videos of the cross as we include videos of all these proceedings in the text version of today's content. First, every facet of the cross-examination was dripping in contempt. The tone of the questioning was consistently snide, ridiculing, insulting, incredulous, and intended to provoke an angry outburst from Kyle, which outburst would, of course, have been horribly destructive to the defense and is one of the major risks of putting Kyle on the witness stand. Binger was big on constantly accusing Kyle of wanting to kill, not merely defend himself with deadly force if necessary and lawful, but simply to kill. You wanted to kill them. I wanted to stop them by killing them. There was a great deal of that kind of thing going on. Binger also spent a lot of time on the AR-15 and the purported illegality of Kyle's possession of that rifle. Of course, Binger is sure, he says, that Wisconsin law supports his position that possession was unlawful, at least in terms of divining legislative intent. He is, in my professional opinion, wrong on that point, but it remains count 6 in this trial, so he may as well hit it. Kyle pushed back pretty effectively here. Kyle gave Black the money, he said, to buy the rifle, but it was never to be Kyle's property until Kyle turned 18 and could lawfully take ownership. In the meantime, Kyle's understanding of Wisconsin law is that it was lawful for him to open carry the rifle, which happens to be my understanding as well. Binger even asked why Kyle hadn't chosen a more convenient handgun instead of the unwieldy rifle, and Kyle told him because that would be illegal. The law allows him to have a rifle, but the pistol cannot be legally possessed by someone under 18. Binger even tried to suggest that Kyle had shot 3 people on August 25th, 2020, because after all, isn't that what you young kids do in your first-person shooter games? Shoot weapons like AR-15s at anybody who comes at you? Isn't that the whole point? And Kyle was obliged to point out that video games are not real life. Less pleasantly for the defense, Binger then introduced an image from Kyle's old TikTok account where his username was 4 Doors More Whores. Talk about poor judgment. His avatar is a picture of him holding his AR. And the comment or subtitle, I don't really know TikTok, reads, "Bruh, I'm just trying to be famous." Binger naturally used this to suggest that Kyle shot 3 people in Kenosha in order to become famous. And apparently it had worked. Binger also spent much time minimizing Kyle's civic activities like his police department explorer and fire department cadet efforts, as well as minimizing his association with Kenosha. Neither of these lines of attack went anywhere as Kyle's responses were reasonable and sound. It was here that Binger attempted to bring in the CVS video footage, which got him in hot water, which we've already described in the Midday Post. Binger touched on the curfew violation as well. The defense objected because count 7, the curfew count, had been dismissed this morning, but Judge Schroeder allowed it, and Kyle simply noted that hundreds, if not thousands of people were around the city, and it reasonably appeared to him that the police were not enforcing the curfew. Binger then decided to start quizzing Kyle on the terminal ballistics characteristics of full metal jacket versus hollow point ammunition, another line of questioning that got him in the hot water with Judge Schroeder, as again we discussed in the Midday Post. At this point, the court recessed for lunch, and immediately after lunch and prior to the jury returning to the courtroom is when the court had the discussion about the motion for a mistrial with prejudice, Binger's explanations of the Fifth Amendment misconduct, his explanations of the CVS video misconduct, and his failed request to admit the free as F t-shirt photo, all of which we've already discussed in this content. When Binger's cross-examination of Kyle continued, Binger began by suggesting that perhaps Kyle hadn't actually even recognized the charging Rosenbaum as the man who had previously threatened to murder him, because now Rosenbaum had removed his shirt and wrapped it around his head. It appears, however, that Kyle was able to see through this crafty disguise. Binger also spent an inordinate amount of time ridiculing Kyle's willingness to provide medical aid to injured people and put out fires. Isn't that the kind of thing we normally just call 911 for, he asked? Injuries and fires? Well, sure, Kyle said, normally. These nights were not normal. Emergency response services hadn't responded on previous nights as the city was being looted and burned, and there was no reason to believe that had ended. At this point, Binger became rather schizophrenic in his questioning, presenting Kyle with a lose-lose scenario for the defense. Either the environment was safe, and therefore Kyle was somehow reckless for having brought a rifle with him for protection, or the environment was sufficiently dangerous to warrant a rifle for protection, and therefore Kyle was somehow reckless for running around providing medical care and putting out fires. Heads, Binger wins. Tails, Kyle loses. This was all, of course, in support of the various recklessness charges against Kyle. At one point, Binger actually asked him why, before he ran to the CarSource 63rd Street lot to put out the purported fire there, where he was attacked by and killed Joseph Rosenbaum, if Kyle felt it was safe enough to do that by himself, with no partner to protect him, why hadn't Kyle simply taken off his rifle at the Ultimate gas station and left it there? I guess on the ground with strangers? I kid you not, that was a Binger question on cross. Then we hit the My Cousin Vinny point in the cross. For those of you who are sadly unfamiliar with the best law-themed movie ever produced, two young men find themselves mistaken for murderers. When told by police that they are suspected of having killed someone, one of the men bursts out in question form, "I killed someone?" This would later be read in court as if it were a statement of confession rather than an outburst of bewilderment. In this real-life trial, it turns out that someone had accused Kyle to his face on the street of having pointed a gun at him. Knowing that he'd never done that, Kyle responded sarcastically, "Yeah, I pointed a gun at you," and immediately turned around and walked away from a situation that could have escalated. Now in court, Binger presented this sarcastic remark as if it were a statement of fact and characterized Kyle's denial of the statement being made seriously as a lie. About this point, the state sought to introduce its unicorn evidence of the magically appearing drone footage that the evidence fairy had left on Binger's doorstep just this past Friday, except now the state wanted to show the video to the jury using the pinch-to-zoom capabilities of an iPad. The defense objected, indicating that they had reason to believe that the video processing software of the iPad might place artifacts within the image that could be misleading. This led to a debate in the courtroom, and when the court came back into session, and the debate in the courtroom was outside the hearing of the jury, when the court came back into session, Binger did show the video footage to Kyle and to the jury, but without the pinch-to-zoom approach, where Binger insisted 3 successive times as he rolled through the video that it showed Kyle pointing his rifle at Joshua Ziminski just before the Rosenbaum chase. Kyle insisted he saw nothing of the sort. All Kyle saw was his shoulder perhaps going up, but the muzzle of his rifle pointing down. I looked closely at this playing of the video myself and didn't even see that much. I certainly did not see the rifle muzzle coming up on Ziminski. My opinion of yesterday remains unchanged. As far as I'm concerned, the unicorn drone video shows nothing at all useful, except yet another view of Rosenbaum chasing down a fleeing Rittenhouse. Binger then ridiculed the notion that just because Rosenbaum was grabbing for Kyle's rifle, that didn't mean he meant any harm. Kyle had simply assumed that the unarmed Rosenbaum meant him harm. Kyle responded by simply pointing out that Rosenbaum had continued to run him down in the face of a raised gun after having threatened to kill Kyle if he got him alone, and now he'd gotten Kyle alone. Then Binger got on a really weird riff where he attempted to equate other people unjustifiably attacking Kyle with deadly force, with Kyle responding to those threats with deadly force, as if who was the initial aggressor was a non-factor. Sure, Grosskreutz pointed a gun at Kyle, but didn't Kyle also point a gun at Grosskreutz? In fact, Grosskreutz had only a little pistol, and Kyle had a big rifle. Doesn't that mean Kyle was being more death-threatening than Grosskreutz? If you think I made that up, I did not. That was actual questioning on cross-examination. On the topic of the angry mob chasing Kyle down and screaming to kill him, isn't that just reasonable and understandable? Binger asked, after all, you just killed Rosenbaum. Tit for tat? Binger also mocked Kyle's claims of being interested in helping the injured when he didn't even bother to help Rosenbaum or Huber or Grosskreutz, as if even professional EMT would have stayed on scene to provide care if there was an angry, violent, death-threatening mob running down on them. At this point, Binger circled back to his original line of attack. You just wanted to kill those people, didn't you? Nope, just stop them. Kill them. Stop them. You shot them. Deadly force. You wanted to kill them. I wanted them to not kill me. You just wanted to kill them. Isn't that true? If that sounds tiresome when I say it, you can only imagine what it was like to listen to Binger say it apparently endlessly. Finally, Binger sought to characterize Kyle as having fled the scene of the crime, even though he promptly turned himself into law enforcement in Antioch, Illinois, where he lived, and had them contact Kenosha PD to send detectives out. At no time did Antioch restrain Kyle's freedom of movement in any way. He simply chose to wait in the unlocked lobby for the Kenosha detectives. And with that, Binger ended his cross-examination of Kyle. The defense had no redirect, and Kyle was out of the witness stand. With the day having been long and the hour late, Judge Schroeder at that point decided to recess the court for the day. But at the day's end, the defense notified the court that they had 3 more witnesses. One is Dr. Black, their use of force expert, whose testimony is likely to be time-consuming. That should happen tomorrow. The remaining 2 witnesses are expected to be relatively quick. And the judge also informed the jury that it was his expectation that the trial would wrap up no later than next Tuesday, perhaps as soon as Monday. And that's where things stand at the close of court business today. Don't forget to join us again tomorrow morning for our live coverage of the trial of Kyle Rittenhouse at legalinsurrection.com. And remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until tomorrow morning, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.